It's now December 8th of 2007, and we're here in Dallas. And I'd like to just ask you, first off, I know you practice law here in Dallas. How old are you right now?
68.
And
I was born in Fort Worth in 1939.
tell us a little bit about your family growing up, if you would, please, sir.
I grew up in Abilene. My father was an independent oil operator, geologist who had lived in Fort Worth and was in Abilene. My mother had people there. She grew up in Chicago. She was down visiting her grandmother and met my father, and they married. And I have two younger brothers, Tom and Charles. Tom is the owner and operator of the celebrated Perini Ranch Steakhouse, which is written up in the current Texas Monthly as the third best steakhouse in Texas.
And there's some months it's the first best steakhouse in Texas, is that correct?
Anyway, and so I went through school there and grew up. And
where did you go to undergraduate school?
I went to Yale as an undergraduate, Yale College.
What year did you graduate?
62.
With what kind of degree?
Just a BA in political science.
I got a degree.
I got a degree at Yale in political science and graduated in 1962.
And when did you go to law school?
I went to law school at Texas, was out a year, and I went on an exchange program to Yugoslavia and wound up spending a year over there sort of knocking around and some traveling in the Eastern Bloc countries and all. It was a wonderful, wonderful experience and opportunity. And while I was there, I caught cold. I was living with students in a student dormitory. We had a severe winter. They turned off the heat, rationing power. I got a cold, and I had gone to the American Library and had a copy of John Dos Passos' book, Mid-Century, which is about a young lawyer, an idealistic lawyer. And I read that book with a fever and wrote home and said, let's see if I can't get into law school. I had been interested in law school. I'd taken the LSATs, but I wasn't sure I wanted to do it, but that settled it. I came back and went to Texas and graduated in 1966. I was a reluctant law student. I was shocked and horrified, and it's the first time I've really not been able to do what needed to be done.
What do you mean? What do you
mean?
Well,
academically, I found it extremely challenging, and I didn't know what to make of it. In time, I redeemed myself. I won, along with my partner Julius Glickman from Houston, the Hildebrand Moot Court competition at Texas in the spring of '66, which is argued ultimately before the whole Supreme Court back in those days in Towns Hall. And it was a nice accolade, and I got the Best Speaker Award. So I didn't leave law school with my head hidden. But I still hadn't been a good student. I didn't have a job and didn't have a plan. I didn't have a wife. I had no obligations. I didn't know I was, you have all of the young person's conflicting notions about things. But my best friend from Abilene, Roger Whitehurst, had gone to SMU and had opened a practice and hung out a shingle a couple of years before. And he said, well, while you're waiting for the bar results, which, by the way, I was really scared I was going to lose the results. I was going to fail the bar. So I really worked hard at it, took the bar, and was waiting for the results.
Well, what year did you take the bar?
66.
Okay.
And took the bar in '66, and so I was sort of spending the summer out at the Perini Ranch waiting for the results. And Roger said, come on into Dallas and start working with me and see how you like it. And I did that, and I've been here ever since. And I remember a couple of years later thinking to myself, I can imagine living my entire life and practicing law in Dallas, Texas. And I'd never been that committed to anything ever before. It was quite remarkable.
So when you first came to Dallas, what was it that ultimately drew you to the practice of criminal law?
Well, it wasn't that I was interested in criminal law. It was that criminal law was interested in me because I hung out a shingle with Roger and discovered, of course, that the one thing that young lawyers get is criminal cases. You can take court appointments and you wind up, representing people, getting people out of jail.
How did the court appointment system work in Dallas County back during those years?
The 1965 Code of Criminal Procedure went into effect the year before I got there. The Dallas County new big white courthouse was opened the year I got there. It was interesting. All these things were going on. And the Code of Criminal Procedure back then required that lawyers in criminal cases be paid by the appearance, not less than $25. Dallas, Friday was plea day in Dallas, I'll explain that in a second because there are a couple of footnotes that are important. And you would go to one of the district courts and ask the prosecutor if he had a case for you to plead. And if you were in good with the prosecutor, he would hand you a couple of case files and say, here are the 2 cases you're going to do, and I'd fill out the plea papers, and he'd tell me something about the case, and of course I'd know the plea offer. And the prisoners would be brought down from the jail, which was up on the top of the building in what is now the George Allen Courthouse at 500 Commerce Street, and they would be on chains and in their white uniforms in the jury room, in the jury box, all over the place. So you would go in and talk to your client. I would go in and talk to my client and say, in whispers, with all the other prisoners sitting and listening, my name is Vincent Perini. I've been appointed to represent you. You're charged with burglary. I understand you've worked out a deal where you're going to get a probated sentence. And let me just ask you about this. It says something about this here. And by the way, we didn't have probable cause affidavits back then.
Well, let me ask you this. Was there an absolute right to counsel at that time?
Well, Gideon was in 63.
Okay.
3 years before, so it was kind of like it's like
just because it's the law, it takes a while to
exactly.
transition.
Brown versus Board of Education in 54 did not end segregation. It was the beginning of the end.
Okay.
And so also this, and so this is the way Dallas was handling it. It's very, and I don't know what they were doing in Tarrant County, but So I would say, I didn't have any information about the case, but what the prosecutor had given me, and I'd say, well, tell me something about this. And the guy would say, well, I went in and I did this, and I went into this apartment to steal something. I said, well, that's burglary. I said, okay. And so you fill out these forms. You have these rights. You don't have to do this. You can have a trial with a jury. You can call witnesses. You can confront the witnesses against you, and so forth. But all in whispers while I'm kneeling down on my knees, with a legal pad. And he said, okay, we're good for this. We need to sign here and here. And I'd do it another time. And then I'd go and turn my file into the bailiff and wait. They'd call my name. We'd go up before the judge, and we would plead the cases one by one. And then I did pay slips. One for $25 and one for $0. Because the deal was, although the code said you couldn't get paid less than $25, Dallas said, well, we're going to pay you $25 for the first case, but you're not going to get the first case unless you do the second case free. So it was $12.50 a felony when I started practicing in 66.
Bless your heart.
And
in 1966, Henry, who was the district attorney in Dallas County?
Henry Wade.
And what was Henry Wade's, how many years was he in office?
I think altogether about 30 years, but of course he was at the peak of his power and prestige about that time, and he molded the office, and he was a great man.
Tell us about the Henry Wade administration, what he stood for and what he did in Dallas.
Well, he was a former FBI agent, and had been an outstanding law student at the University of Texas, and he ran a tight ship, and his people then and now, even the legacy, it's double time. They would do everything hard charging, and he was an extremely competitive man, and he wanted to win at the business of being a crime fighting DA, and so there were things like remarks that attributed to him like, well, the conviction's on page 1, but the reversal in 2 years will be on page 15, that sort of thing. And so he didn't try to reform criminal law practices within his office in the cases. We let the Court of Criminal Appeals take care of that. He was just winning cases right here and now in Dallas. And they still do to some extent, but it's all changed. He used the grand jury as a means of culling cases, and I believe they really applied a curve because month after month, quarter after quarter, the grand jury would no bill 25% of the cases, 30% of the cases. That was very commonplace, and his idea was get rid of the poorest of the cases, so the ones we've got are really solid. And one time I happened upon him addressing a newly impaneled grand jury. And I sat down to see what the great man would say, and I heard him tell them, don't indict everything that's brought before you. You're not going to solve the problem of crime in Dallas. You can't do it. Give us cases we can try and win, and get rid of the ones that have problems with them. And I know he directed his people in the grand jury to do that too. And so in Dallas, in those days, and right up until now, there's been a tremendous grand jury practice, because you can resolve your case in the grand jury, and I've done it many, many times.
Well, so you spent your first, your early years as a lawyer doing criminal defense work in Dallas primarily.
I did anything back in those days. It was fun. I'd get reversals. I did probate. I did things. I had some friends in the firms. My friends in the big firms from law school would send me business, stuff that they couldn't handle. And some of it were folks from those firms, little cases, probate here, this, that, or the other. I did all sorts of stuff. For a time, I was doing interpleader cases for a good friend, Bill Kramer, who was one of the partners in the Plano Title Company. And I was up in Collin County filing interpleaders all the time. It was I said I won every case. It was fantastic.
How long was it until you gravitated almost exclusively into the criminal practice?
Well, this has to do with the Texas Criminal Defense Lawyers Association, because what happened was I was extremely frustrated. There were almost no books. Ray Moses had a book in Houston, Judge Fred Arisman's famous Red book, Paul McClung's wonderful jury charge book. Paul was from Fort Worth and was a federal employee, worked for a federal agency, but as a hobby, he read criminal cases and kept that book up. A marvelous book. He had a heart condition and was told he couldn't practice.
Wow.
But those were the books, and Moses's book was a general procedure book, but there was so much. And so the way you learned criminal law was to work for the DA's office, and I had not done that because I came to town to hang out and shingle with my friend from Abilene. And boy, I mean, I just got rocked and socked and learned the hard way with my clients, I'm sorry to say, on the receiving end of my failures and shortcomings as a young lawyer. Now, my frustration caused me to want to abandon criminal law and get out of it. And
What year was that you wanted to leave criminal law?
Well, from the beginning,
criminal law.
I had no zeal for criminal law. I wasn't. This was no great love of mine. I didn't know where I was going, and so I was ready to say that's my last criminal case. And yet something would draw me back, and I kept coming. And then, in about 1972 or 71, I got the letter from TCDLA inviting me to be a charter member. And I said, hallelujah. This is exactly what I need.
Tell us, were you a charter member?
I was a charter member. I was a charter member of TCDLA.
How did TCDLA begin?
It started because some of the prominent criminal lawyers in Texas, Phil Burleson from Dallas, Tony Freelow from Houston, were the two engines who really did it, and then there was another dozen or so or more from around the state. And Frank Maloney was the first president, but he was a compromise because Freelow and Burleson sort of had a competition, and they couldn't decide who would be first. And I think that was understood, and I think Frank would be the first to tell you that that's the way it was done. And then Tony was second, and Phil was third in line. And then but
and that was what year?
71 and
was there actually
71, 72. I can't actually remember, but. We were the first organization of our kind in the United States. We were ahead of California.
Was there actually an organizational meeting of some kind?
I was not there. I'm sure there was, but those guys were sort of doing it themselves. When I got a letter from the TCDLA inviting me to be a charter member. I don't remember an organizational meeting as such. It had already been done.
Okay.
I mean, they had it set up with the membership. And I got their attention and Burleson's attention. I was in Dallas as a, imaginative young lawyer, and so I wound up on the board.
So you would have been practicing law how many years in 1971 when the Texas Criminal Defense Lawyers Association was formed?
Well, I mean, only about 5 years or so. And went on the board, and another rising star was Stuart Kynard from Houston.
Tell us about Stuart.
Stuart and I were both on the board. Well,
tell us what you remember about Stuart.
Stuart was just a wonderful lawyer and a wonderful person. By the way, he's from Sweetwater, Texas, 40 miles upstream on the Clear Fork from Abilene. And Stuart was just a marvelous, imaginative, charming person. And the death penalty was cranking up in the 70s, and none of us had experienced that before. This was the new post-Furman death penalty that we now have in place. And I remember Stewart doing a voir dire demonstration in a death penalty, and it was, I think, in the auditorium of the University of Texas at some seminar, and you could hear a pin drop, and he was unbelievable. He was so imaginative, so good, but the stresses and strains took a toll on him, and I don't really know, but he had a divorce and some problems, and that's a problem for all of us. We tend to become workaholics and forget that it's a balancing act. Being
tell us about that.
A practicing lawyer, and it's happened to me.
Here at 68 years old, what can you share with the young lawyers emerging into the criminal practice as to how they need to balance their health, their family life, with the demands of a career?
I will let one
answer it. Where you
let me talk about the business of balancing life as a trial lawyer, and remembering your family and the other persons who are important. And I will let one of my former wives speak for me, because at one point when I was doing all this stuff in indigent defense, which has been a great cause of mine at different levels, and I've done all sorts of things over time, she made a comment, because we had money problems, and we had a young son at the time, 4 years old or something like that, and she said, well, you may get a great deal of satisfaction and benefit from sacrificing on behalf of indigent criminal defendants, but your son doesn't.
Okay.
And I'm so smart and clever, and that just hit me like a slap in the face. She was absolutely right, because where was the money for college and private school, need be, et cetera, going to come from? And the answer was, I was giving it away right here and now for working for free, doing all these things that, of course, gave me tremendous pleasure and satisfaction and accolades, one of which is right here being interviewed by you. But the truth of the matter is, I had failed in those other departments. And even though for years I've taught and written about making money in the practice of criminal law, and it's quite ironic. And the answer is, you just have to work at it. And I wouldn't hesitate to work late at the office, because that isn't this the American way? You just work hard and hard and hard and succeed. And the answer is yes and no. And the no is, you can't, don't throw yourself away, and don't, for heaven's sakes, cause that to happen with your children and your wives. You've got to take care of that.
What would you do different today, V? If you started over at 25 years old, what different steps might you take?
I'll tell you, it's a very hard question to ask. How would I have done it different? Because I really don't know. Because it is so demanding, and we all know that when you're in trial, the first really serious crisis in my first marriage was when I went to trial in a case. And my wife was just kind of beside herself, and I couldn't understand. Why, don't you understand that this is what we do, and I'm a lawyer and all this stuff? But I realized there was something different. There was a problem. And because I was so absorbed with the trial, I just wasn't there, even if I were there physically. And every trial lawyer knows that feeling. And so you've got to try to balance it. That's all there is to it. And you've got to work smart. There isn't enough time to do everything that needs to be done unless you're very careful the way you do it. And it's almost an impossible task, because being a trial lawyer running a law office, you don't make that much money in criminal law. It's hard. And advice I give to lawyers who are going out of the DA's office or going into criminal law, I say, do not, even if you love criminal law, don't embrace it as the only thing you do. Do civil trial work on the side. Learn that now while you're fresh, and nobody will criticize you for not knowing what you're doing, because you have a grace period of several years. Seize on that to learn how to do it, and then, if possible, do both practices, because they complement one another. I think that's true. I think you're a better criminal lawyer for doing the civil, and vice versa. Okay. And that's something I would have done different. Before the Bates-O'Steen decision, I decided I'd limit my practice to criminal. And in retrospect, that was probably a mistake for the economics involved.
Okay. You mentioned that you were a charter member of the Texas Criminal Defense Bar Association. You later became an officer and ultimately president of that association. Did you not, sir?
Correct.
What year were you president of the Texas Criminal Defense Bar Association?
I was president of TCDLA in 1979 and 1980.
What do you remember about about your year as president, the changes, the challenges that you had to deal with that year.
My year was a year of financial crisis, and of course I'd been on an officer and director, and I was responsible for that just as much as anybody else, but we didn't see it coming. We didn't have the money we had had before. Until that time, there was a full-time lawyer executive director of TCDLA. That year we had to abandon that, and we just had a secretariat and an office in Austin. So that put me under tremendous stress as the president, as well as the office and the organization. It was a hard year financially, and we pulled ourselves out of it. And I think the following year we hired Steve Capel as an executive director, now a federal magistrate in the Western District, and you know, the rest is history. But that was a very hard time, and it was hard on me. Also that year, the president-elect was Bob Jones in Austin, and Bob and a number of other prominent TCDLA leaders were badly injured in a car wreck. They were all together going over to one of the famous barbecue places in Central Texas one Friday afternoon, and they rolled their truck and were badly hurt. So Bob wasn't able to help. I mean, he was in traction. And I think Scrappy Holmes may have also been a victim of that wreck. It was hard on us. So it made a difficult time. Now, what was happening then in Texas was fun, because Bill Clements had been elected governor, to everybody's surprise.
That was 1978.
In 78, yeah, the first Republican governor since Reconstruction. And one of the things that was going on then, big time, of course, were drug cases and the problem of drugs generally, and the nation. You know, today we're used to that. It's hackneyed, it's old news. But back then we were still grappling with it. I mean, what should be done? What can we do to get a handle on this problem? And so Governor Clements appointed his friend from Dallas, Ross Perot, to be his drug czar on the war on drugs.
What were your initial thoughts when you understood that Ross Perot was appointed as the czar on the war of drugs? You're from Dallas, and certainly is the Perot family. What was your initial
Well,
concern?
we knew about the Perots, but he had not made the name for himself in public life that he has now. I mean, that was one of his first forays into public life. And he hit the ground running, and it's interesting because, you know, he's a very focused person, and he's a very outspoken person. And one of the first things he discovered, that all these people who were selling drugs and creating all this crime and mayhem in our society had lawyers. And it upset him very much. And it's very amusing, except that he really, you know, he hadn't thought it through. He just really didn't understand it. And he had a tendency to talk first and think later. And he said a lot of harsh things about members of the bar. We were up in arms about it. We were very, very upset. We had a board of directors meeting in San Antonio where this was the subject. What are we going to do about Ross Perot? He's maligning us. He's saying things about us that aren't right. This is so outrageous. And so we decided to have a delegation to go talk to the governor, to ask the governor, would you please instruct Ross Perot to cool off and to stop attacking lawyers? And the delegation was of three: myself, Bob Jones, who was president-elect, and Wagner Carr. Wagner Carr had not been a criminal defense lawyer until just a few years before. He'd been the mayor of Lubbock and had been attorney general, and was on an upward climb to be governor, certainly. When he got indicted in the early 70s in the infamous Sharpstown scandal, banking scandal, wound up being a defendant in a federal trial in Dallas representing himself. But the main lawyer in that trial was Emmett Colvin, who was one of two or three of the most prominent criminal defense lawyers in Dallas, and the president of TCDLA along about that time. So Wagner was acquitted and became a member of TCDLA and was a faithful board member. And at that time, because of his work in government and politics, he was one of the delegation that went to see Bill Clements. And we went over there and had a nice visit, told him our problems, and went home. And I don't think anything ever came of it. It's amazing to me now that we even tried to do it. But that shows how strongly we felt about the insults that we were getting from Perot.
Well, that was one of the first efforts legislatively on behalf of TCLA. Is that correct, sir?
I'm not sure that that was the first effort legislatively. One of the reasons the organization was formed was to have an effect in Austin. And I think they saw the success of the Texas Trial Lawyers Association. And we were going to do what they had done, only in the arena of criminal law. What they didn't realize was that the trial lawyers just had more money because of what they were doing. And back in those days, before a lot of the things that we now come under the umbrella of tort reform, trial lawyers were making a lot more money than we were, and they were able to fund their efforts where we weren't. We didn't have that money. So from the beginning, we were in the legislature. But that year I was president, it was really hot and heavy because Perot and company proposed the wiretap law, the first and the one we still have. And, it was hotly controversial.
You mentioned a person we all have respect and admiration for a minute ago, Emmett Colvin. I don't mean to interrupt you, but tell the people watching this video about Emmett Colvin, what you remember about Emmett.
Well, Emmett Colvin was an intellectual. He'd been in the military. He'd been a photographer in intelligence in World War II and remained throughout his life a very, very fine, high-class photographer. And he had lots of interests like that. And he was he was a wonderful wordsmith and a great lawyer, and I never knew him as a teacher. That was one of the problems we had in Dallas. There wasn't enough of occasion to have him and the others teaching us until TCDLA came along. But Emmett was a soft-spoken, very, very smart person who was dedicated to TCDLA until the end of his life, and was just a great leader. The other great lawyer in Dallas at that time was Charles Testmer. And he was fantastic in the courtroom, but I think he was kind of timid and shy, reticent. We didn't have people who were very good teachers, and that was one of the real problems, that TCDLA filled the void.
Well, you mentioned filling the void in teaching and education. You've always had a passion for that, have you not, sir?
I have indeed.
And answer my question.
I have had a passion for teaching, and I've been very lucky to have some great experiences, but the whole business of CLE was terrible when I started, and I put on a very successful seminar for TCDLA in the early 70s here in Dallas.
Where was that? What was that? Here in Dallas?
It was in Dallas. It was a one-day seminar, but we just had very high standards. I mean, people who are accustomed to CLE today, the Rusty Duncan, for example, would be amazed. You would go to a program and somebody had a topic, and there would be one page. It wouldn't be an outline. It would be just a list of words and phrases. This is what he's going to cover. It had no substance itself, and then the coverage was haphazard. Or a lawyer would pick up his dictating machine and dictate a narrative war story, basically, of some matter involving discovery or jury argument, and that would be his presentation on discovery or jury argument. But it was ragtag, and so I put on a good seminar with good outlines, and then I was also an adjunct teacher at SMU, and that was wonderfully stimulating for me. And then in the mid-70s, the bar at large in the United States and Texas, everywhere, were trying to deal with the fact that there was not a good way to connect prospective clients with lawyers. How do you find a lawyer? Because in those days, solicitation was a grievable offense in the bar. You could not solicit business, although we all knew it was done all the time. But certainly no advertising. You were prohibited you couldn't go to the State Fair of Texas and hand out cards. I mean, you just didn't do that. And you get in trouble with the bar for it. So how do you bridge this gap? And so specialization was a solution that they had devised, and that was born of necessity because they wanted to advertise in the yellow pages and things, but the bar did not feel that we would just let the lawyers decide what their specialties were without regulation, for good reason. So Texas established a advisory committees in 3 fields, labor, family, and criminal, to come up with a proposal for specialization.
Were you on that committee?
I was on it, and that's
Tell us about the genesis of that committee.
well, that was the and Bill Derrick in El Paso was the chairman of the Board of Specialization, and it's it was the beginning of the apparatus that we now have for specialization.
Being the Texas Board of Legal Specialization.
Exactly, the Board of Legal Specialization, and we wrestled with what to do, and there were all sorts of ideas. I mean, and some states had employed, for example, if you got 10 letters from 10 lawyers and 5 letters from 5 judges saying how great you were, you could specialize. But we knew, that's not going to work, and that's not right. And I, who had been a reluctant law student, and I've heard myself saying there's just no alternative to an examination. And I thought, I can't believe this, but that's the only way you can do it. It's got to be like a bar exam. Because one of the problems were the older lawyers who had a reputation, but they weren't keeping up and stuff. And of course, we did not have the CLE, and there was no mandatory CLE.
So what year was that the specialization?
Well, that was about 74, 73, 74. And so we came up with our proposal for specialization. Well, as a result, I mean, I wasn't sure the specialization was going to help at all. But I thought, well, you know what? If we have a really top flight course, an examination, and a course to prepare for it, that itself will justify specialization. It will be a bootstrap operation. If you weren't a specialist when you started, by the time you got your certificate, you would be. And that really is the program we have today. And then I came up with the idea, let's do a course that's like a bar review course. And multiple days and covering everything, and so
what year was that y'all actually?
That was in '75, and I wrote to Phil Burleson and Bill Derrick and proposed a multi-day course, higher standards than anybody had ever had before, et cetera, et cetera. We'd pay the speakers and writers. We'd require outlines and outline form, and I took the BRI outline, the bar review course. I took a page from their constitutional law outline, said this is the outline form we're going to follow. We made everybody follow it, and it's very exacting and rigorous. And anyway, the very first advanced course was the criminal law course at SMU in the summer of '75.
And who was the course director?
I was the course director, and the State Bar hired me. And this is the first book, and I've got that's the cover page that somebody, I think in Austin at the State Bar, had written in hand, had done the lettering for the first page. That's how primitive things were 35 years ago.
So the first advanced criminal law course was held July 14 through 18, 1975.
Right.
And where was that course?
It was in Dallas at SMU.
And tell us about the accommodations.
Well, of course, nobody had ever done that before, where you'd had it day after day. People would be coming from out of town. So we arranged for them to stay in the dormitories at SMU. Because there were so many subjects, we broke it up and had evening sessions. There was a morning session, generous lunch break, afternoon session, generous dinner break. I arranged for them to be able to go swimming at the natatorium, and then we'd have an evening session.
And how many days did that extend over? 5 days?
Yeah, I think it was 4 or 5 days.
Monday through Friday.
The week. And anyway, it was hugely successful and everything about it, and it was the beginning. And then they put on the family law course later that summer,
Do you remember what organizations or associations actually sponsored the
Well, if you look at this, it was the State Bar of Texas with the Texas Criminal Defense Lawyers and the Criminal Law section of the State Bar.
And the SMU School of Law.
Yeah, there was a precedent, because for a few years before that, at the State Bar Convention, we had put on about a one-day seminar with these 3 groups working together. So again, we were working together now, but this, of course, was a super course.
How many attendees at the first course, if you remember?
I don't remember, but we filled that downstairs lecture hall they had. So it was pretty, it was a pretty good group, and I've got data on the numbers and the dollars and so forth.
Now, for those people that are watching this video now, that course is now 33 years in existence, correct, sir?
Well, yes, the first one was in '75.
It's grown to how many attendees? And one year they had 900, if I recall.
It's staggering, and the family law course also. And I'll tell you, the State Bar in 1975 was in difficult financial straits because they'd built that new building and they were having problems, and the executive director was Hayden Pittman. And I don't know any of this, but I think they saw these advanced courses and thought, wow. And of course, you know, they've been charging a lot of money for it ever since. And of course, it's been a huge boon to the budget. It's been great for CLE. I mean, I think we made a mark nationally. I mean, set a high bar for the quality of CLE, but it's been a great money generating source for the state bar, which is just fine.
You've had some thoughts and memories about that first course, and even shared them with Buck Files back in 1997.
Well, I wrote Buck. Buck was the director of the Advanced Criminal Law course in '97, and I wrote him a handwritten memorandum, which I've got in these collection of things I have on the first course.
Does that summarize some of your thoughts and feelings about the course?
It really does, and if you'll let me, I'll just quickly read it. But it's interesting because
Please do so.
It also contains some of my thoughts on the way the courses ought to be. And Buck, of course, a prominent Tyler criminal defense lawyer and leader in TCDLA, and so I wrote this to him. I think he made some inquiries to me because he was going to be the director. And so I said, Buck, I found CLE abysmal in my first years of practice. Then in 1974, as a member of the Criminal Law Specialization Advisory Committee, I was inspired by the thought that requiring an examination would in turn induce production of a first-rate review course. Specialization would become a self-fulfilling prophecy, bootstrapping the quality of specialists by the very process of specialization. I proposed the idea that the state bar then was hired to do the first criminal law course. I think it's the best thing I have ever done. I think that's probably right. Because speakers and writers would be required to meet new, much higher standards for their work, I proposed they receive an honorarium. In financial trouble, the state bar abandoned this the next year, taking all the money for itself. The advanced courses became the foundation for a CLE cash cow for the state bar that continues today. I've complained of the gradual degeneracy of the quality of writing and especially speaking and so forth, and I mentioned you can call me if you want to hear more about that. And then I said the state bar also abandoned the descriptive word refresher. The first course was called the Advanced Criminal Law Refresher Course because I saw it as like a bar review course. How great now that I'm practicing to go back and get some of those foundation concepts from academicians and people who, you know, in law school it made no sense. And so, continuing on to Buck, the state bar also abandoned the descriptive word refresher, a mistake in my opinion. If we thought more about refresher, both in the papers and the lectures, I think the papers and lectures would be better if we thought in terms of, let's go back and ask ourselves, what is this all about? How did it start? How did we get where we are? As for written materials, less is more. I believe the State Bar of Texas thinks we're all fools and that we judge quality by the weight of our binders. In the beginning, we required an outline form, which I plagiarized from the BRI Bar Review course, much more useful than today's shameless windiness. And, you know, we all know what we're talking about. And now with the automatic typewriters and the computers and cut and paste, it's a lot easier to take a huge chunk from a case and put it in your outline than to analyze it and summarize it in a brief three-sentence paragraph. And so that less is more, and I still believe that. Afraid my troops would be compromised by nighttime carousing, as well as concerned that the sessions would be impossibly exhausting without breaks, I scheduled night sessions, as you recall. It was all very quaint, wasn't it? Best regards. And that's a good summary of my feelings of that experience. And of course, the history of the CLE with the advanced courses and mandatory CLE are all now in our history and very much a part of our lives as lawyers, and certainly the net result is far better for everybody, including the public, because the quality of lawyering is so much better.
Vince, I can't help but do it, but I want to show the people that are watching this video your photograph of the Texas Bar Journal back in 1975, if they can see it up. And it also has a picture of you with the other course directors planning. And who are those other? Who is Gary DeShazo and who was
Gary
Frank
was
Maloney?
the paid executive director of TCDLA, and he is a lawyer in Austin. And Frank, I think Frank Maloney was there in the picture, and I don't know who else is there, but.
Matter of fact, tell us who all the planning committee was at that first course, sir.
Gene Cavan was head of CLE at the State Bar of Texas. Jack Reynolds was at the State Bar. Jane Wells was with the State Bar. Stuart Kynard, Frank Maloney, Steve Dykus, Assistant Dean at SMU. Tom Hanna, who was Criminal District Attorney in Beaumont. He was a speaker and writer and a great leader. Richard Wells at the State Bar. Bill Derrick, an attorney in El Paso who was head of the Specialization Board. George Gilkerson in Lubbock. And Bill Coleus from Amarillo. And Charles Kalin, attorney and chairman of the Bar CLE Committee from Houston. Phil Burleson, Dallas. Dane Whitworth was the executive director of the Texas District and County Attorneys Association. Mark McLaughlin, who was a lawyer from San Antonio, and he is a lawyer from San Antonio, and Gary DeShazo, executive director, Texas Criminal Defense Lawyers Association, Austin.
Vince, tell us a little bit. I understand the concept of the State Bar Advanced Criminal Law course later was utilized by the Texas Criminal Defense Lawyers Association in 1988 when we began our own annual program. And tell us your thoughts about what's now known as the Rusty Duncan law course.
I think what all of this says is that the bar was ready for really good quality CLE. It's necessary, of course, to do what we do. And so this was a major step forward in improving on CLE in Texas and elsewhere, and then the TCDLA followed suit with the Rusty Duncan, and probably today the Rusty Duncan is a better course than the Advanced Criminal Law course. I mean, the same people do it, and by the way, it's a credit to the members of the TCDLA that they generously give their time to the State Bar when they're called upon to do it, and even though, TCDLA doesn't share in any of that money, we didn't in the first year, but at least the acknowledgement was there. But the Rusty Duncan is a fabulous course, and the standards that were set by the first advanced courses are the standards that hold today, and they're very high compared to the way it was when I started practicing 40 years ago.
Vince, you're now 68 years old. You've practiced law for 42 years, is that
42
correct?
years. Yeah.
How many years?
41 years in the practice. 66.
And if you had to think back and try to isolate perhaps the three most significant cases, not just the wins, but the three most significant criminal trials you've been involved in, tell us a little bit about the first one that comes to mind.
Well, the first one was I represented, along with Frank Hernandez in Dallas, black militants in Dallas, and we had a...
What year was that?
The trial was in 1968, in August of 68, an unbelievable time in American history. They just had the Democratic Convention with the riots in Chicago. 68 of all years is the year of explosiveness in American history of that time, the epitome of the 60s civil unrest and strife. And these poor guys were indicted and tried, and I represented them, and frankly, I mean, I just wasn't I thought I was hot and confident and mad and ready, but I just didn't have the experience to do well. They were both sentenced to 10 years in prison. These two guys, they were SNCC leaders. They were Matthew Johnson and Ernest McMillan, and they were SNCC coordinators, and with Stokely Carmichael on the East Coast in Atlanta. I mean, it was the national organization, and they were organizing Dallas, and Dallas had never seen anything like it. And they were scared to death that they were going to start a riot. And they had been doing peaceful picketing of white-owned grocery stores in South Dallas. And somebody gave them some bad advice, and so one day they went inside the store, and then there was some spontaneous breakage. It amounted to about $200 worth. But in those days, it was still under the old penal code. The difference between felony and misdemeanor was $50. And so they were indicted, of course, and charged with all of the breakage because it was clearly a conspiracy, and they were known. The people at the store didn't know the other people, but these two guys had a high profile. So they indicted them and charged them with the full amount of damage in the store. And it made felonies. It was criminal mischief, and it's called intentional destruction of property. And for some reason, the legislature had raised the punishment to 20 years for that. So we were looking at 2 to 20, and they got 10 to do. And it was quite remarkable. I mean, it was a big deal in Dallas.
That was in 1968. What other cases come to mind in your 2 years of practice?
Probably the most important case I had to really put my name on the map, I represented the wife of a young physician who was accused of murdering her adopted infant child. And it was one of these circumstantial evidence cases where the child died of an unexplained head injury with a little, mark on its head that suggested that the child might have been thrown into a little decorative piece in the bathroom, and the woman was preparing to go on the whole family was moving to London to do a residency there. Anyway, the child died, about 30 days old, or just a very young infant, and she was indicted for murders out of Irving.
What year was this?
Well, it was in the mid-70s.
Okay.
And anyway, I represented her, and she was acquitted. And it was, I was really, then I really knew what I was doing. By then I knew what I was doing. I was teaching at SMU. I had learned myself. I'd learned how to do it. And I won that case, and that was a great victory. It's interesting because, of course, I've never worked for Wade, but he obviously knew who I was. And I remember standing at the elevators downstairs the day after that verdict, and it was covered by the press, and there was Henry Wade. And I kind of looked at him, and I really expected him to say, well, you did a great job, and congratulations. He would not acknowledge me and would not give me eye contact. And I think that's a comment on his competitiveness. I mean, I had beaten his office, and he was personally offended. Anyway, I went up another case. I represented a woman whose Rottweiler dog had killed her infant, and that was in the early '80s. It was just a very interesting case. It got a lot of play because of the facts, the circumstances. She was convicted of a lesser offense, but it was a substantial victory, but extremely interesting. And then later on, I talked about grand jury practice. After they passed the concealed handgun law in Texas, which was very controversial, and lots of newspapers, including the Dallas News, were strongly against it, and I personally had been against it. I thought that was ridiculous to increase the number of guns on the street. Anyway, soon after it became law, this gentle man who was drove a pickup truck and had something to do with the welding industry, was on the streets of Dallas and wound up in a fender bender with another driver. And one thing led to another, and the other driver came out and started pummeling him with his fists. And the guy had a concealed handgun license, and he had a handgun under a towel on the front seat, reached over. The other guy was holding him like this, and hitting him in the face through the window. The guy reached over, pulled out his Glock 9mm, and fired one shot right through the breastbone of the assailant, who was a big 250-pound 28-year-old. And the assailant walked back to his truck, sat down in discomfort, and died later at Parkland Hospital. It was the first killing under that law. Well, it was exactly what the opponents had warned against. This isn't going to protect women from rapists and men from robbers. It's going to be something that's manifests itself on the streets of our state in road rage. And this sounded like an example. And the news came out with an editorial that we have to make an example of this defendant, and this is just outrageous. Well, I was just appalled. The Dallas News was not only writing the story up, but on its editorial pages, basically excoriating this defendant. So I wrote them back a real hot defense, the law of self-defense, and of course, and they didn't publish that, but there was so much publicity that I felt that I was entitled under the First Amendment to do it in self-defense. And my client was not interested in talking at all. He was very shy. And so I talked, and I was interviewed a lot, and I had a lot of, it certainly the most fun time I've ever had. But anyway, one thing led to another. He was no bill by the Dallas County Grand Jury, and I made a big presentation to the grand jury, and he testified and all this stuff. And that's an example of how in Dallas we have a tradition of resolving the cases at the grand jury rather than a big trial later on in district court.
As we wind this down, can you, here in your 42nd year of practice, what items of advice, what three things would you tell a young lawyer coming out of law school in his first several years that wants to emerge into the practice of criminal defense work? What things might you share with them?
I'm glad you're asking me how I would advise a young person, but I have to say that I'm very humble and perplexed because I'm not sure what to say. I mean, it's been a wonderful life. It's so thrilling and exciting and interesting and so human to practice criminal law, and that's what's so appealing about it and so rich about it. But economically, it is not rich, and of course there are people who have made a lot of money in criminal law and do and will, and hallelujah, that's fine. But it's just like in the actors in Hollywood. For every Paul Newman or a Nicole Kidman, there are thousands of waiters and waitresses and aspirants who never make it, and that's true in criminal law. And of course, the indigency is overtaking us all. We're basically in criminal law going to become the provision of indigent defense, and of course that's huge. That's been a big part of my professional life too. And now in Texas, with the Fair Defense Act and the apparatus put into place to make it work, that promises a better situation for those who do represent indigents.
Which was something you were very instrumental in, 5 years ago, correct, sir?
Well, I was more instrumental earlier, but I've been doing it my whole career at different levels, and that was a huge success for us, and I'm very glad that got done. But I think in the future, most cases are indigent now in both state and federal court because people just don't have the cash to pay for a lawyer the kind of work and commitment that it takes. And that brings us back around to the question of balancing. Because what happens is you don't have enough money to hire paralegals and all these people you need to do to work your cases. But you know it needs to be done, and you wind up doing it yourself. And the problem is you do it at the expense of your children. And that's what I've done. And and then your marriage breaks up, and you really burden the children because now they're growing up in a divorced family, and that is that's a terrible thing. And in the words of my former wife, you may get off doing all this stuff and you're so wonderful, but your son doesn't, unless it's translated to dollars that he's going to see later on in his life, and that's a huge challenge. And I think it's practically insoluble. And I don't know what to do. I mean, I think that the idea is you have to do other areas of practice. But of course, that's the whole economy in America and the legal economy. I mean, it's a very huge dollars being made by the big firms, and a wonderful marriage between American business and the big firms, and that works beautifully. They're tax deductible dollars also that those firms pay. It's just like the phone company. I mean, they don't question legal fees very much. But out there in the area of family law and the areas of criminal law, you're just dealing with after-tax dollars, and people don't have them. And then in the plaintiff's bar, remember, it's money, and the money from the defense bar in those cases all come from the same source, insurance.
You might have already done this, but as we wind this down, any concluding comments or words of wisdom you'd like to share with the folks who are watching this video?
Well, I think that the important thing is that I was an early president of the Texas Criminal Defense Lawyers. I'm very proud of my contribution to that organization, and very proud to have had that honor. And the Texas Criminal Defense Lawyers Association was the first state criminal law association in the country. California grew to be huge and is huge, but we were first. We were the template. The National Association of Criminal Defense Lawyers was a social club of prominent criminal defense lawyers. I used to attend their summer meetings, and they would get together with their families at a golf resort and play golf for a few days and talk over things. And they had money and power and influence, and they would try to influence legislation. But there was no infrastructure to speak of. And it took them a long time to change that. And we probably, in many respects, were a prototype for the national organization because of what we had done before. So I am a criminal defense lawyer because of this organization. But for the TCDLA, I would have gone elsewhere because I was increasingly frustrated with what I needed to do my job right. And because of TCDLA, when I got that letter, I remember that moment. And I said, well, glory be. This, because they talked about the stuff. We're going to get together and fight these battles and do these things and stuff, and won't you join us? And I said, you bet. And here I am, and I did it. And of course, that was a kick in the pants, and I got to know all these prominent defense lawyers from around the state. I mean, George Gilkerson and Travis Shelton and guys from Lubbock, and like Bill Colias I mentioned. And of course, Phil Burleson was wonderful in Dallas, a wonderful creative organization man. He might not like that adjective, but that's the truth. He was brilliant at that, doing that kind of thing. And so those people were wonderful, and I was in contact with them, and it changed my life. And despite the moments of woe that I've described, it's been a wonderful ride.
It's a good way to finish. I think we're done.